To Landmark Chambers Nuts and Bolts Possession webinar. We are delighted to see so many of you joining the session, and I hope that you're going to find the presentations and discussion to be useful and informative. My name is Miriam Seitler. I'm a barrister at Landmark Chambers, and I'll chair the session today. I'm joined by my colleagues Sophie Gibson and Kate Traynor, who I'm going to formally introduce to you in a moment. So to begin with our brilliant speakers for today, starting firstly with Sophie. Sophie is a specialist property practitioner. She's in her second year of tenancy. In that very short time, she's made oral submissions in appeals in the Court of Appeal and the Upper Tribunal. She's also been successful in trials in the County Court and the First Tier Tribunal, dealing with commercial and residential property matters, respectively. She has a particular interest and specialism in issues relating to land registration, equity and trusts, and also the right to manage. Possession proceedings are her bread and butter, and she usually has at least 2 possession matters a week and always has CPR Part 55 open somewhere on her laptop, which is what she's going to be speaking to you about today. She's also on the editorial team of the Housing Encyclopedia, being the leading and authoritative practitioner's text in this area. So she's going to speak to you first, and then Kate Traynor is going to speak to you specifically about possession claims by receivers. She was called to the bar in 2019. She's also a specialist property practitioner, and her particular expertise is in interrelated areas such as tax, insolvency, and rating law. She frequently appears in all courts and tribunals up to the Court of Appeal, and she's recently drafted written submissions unled in the Court of Appeal. That secured a dismissal marked totally without merit, so she's had recent success there. She too is on the editorial team of the Encyclopedia of Housing Law and Practice, and is a contributing editor to publications such as LexisNexis Property Disputes Practice Areas and Estates Gazette Q&A on property-related issues. So you have real experts with practical experience speaking to you today, and we're going to kick off with Sophie.
Good evening, everyone. Thank you for joining us, as Miriam has said. You're in for a wonderful evening of procedural law on possession proceedings. Now, I'll be talking about Part 55 being our procedural guidance and framework for possession claims. The rules are available online, so if you want to pull them up on a second screen, I recommend, because I'm not going to be reading them out verbatim, and it's helpful to have them there as some guidance as well. Now, in terms of what I'm going to cover in my talk and what I'm not going to cover, on the whole, it will be coming at procedure from a residential property point of view, because based on previous attendees, that's been our main audience, and it is mainly what I do at this point in my practice. But naturally, CPR Part 55 applies to both residential and commercial property. I'm going to be talking about how to start a claim. Which forms do you use? Do you use the standard forms? Do you draft in Microsoft Word? Which court do you issue in? The County Court, the High Court, and when do you choose which court and why? And then the defendant's response, what to do if you receive it, and when should they file it in time. Furthermore, how to serve the claim, when to serve the claim, and practical tips and experience on what actually happens in this first hearing, what to expect, and how to manage your client's expectations. And then I'll address very briefly what happens after the first hearing if you get that far. I shan't be talking in any detail or particular detail about possession claims online, being a particular way for you to issue specific possession claims relating to rent arrears. Those are all contained, the rules on that are in the practice direction. I think it's PD 55B, I believe, or A. I shan't be talking about the accelerated procedure for Section 21 claims, both because it's quite technical and also because who knows, it might not still be in force after the Renters' Rights Bill comes into action. I shan't be talking about mortgage possession claims. There's plenty of Landmark Nuts and Bolts talks on that on YouTube already, so feel free to go and after this seminar, go and watch those as well. I shan't be talking about IPOs being interim possession orders, even though I was in court on one on Monday. This is a particular procedure used only in certain circumstances, including when squatters, persons unknown, are in possession of particular premises. It's a very small subsection of Part 55 with its own rules, so I shan't be going into that. And I shan't be going into the particular service requirements on how to serve persons unknown, the stakes in the ground, the transparent envelopes, etc. Those are all quite self-explanatory in the rules themselves. In terms of then Part 55 itself, it's in largely, I'd say, 4 parts. Your first chunk is on general rules, rules that, unless otherwise stated, apply to all the sort of subsections of possession procedures, including mortgage possession, accelerated and IPOs. And then you have a section of rules on the accelerated procedure, which is the Section 21 claims. And then you have the rules on the IPOs towards the end. And the rest of it, as far as I can tell, is Wales. So if you have a house in Wales, then have a go and read that. I've never had to have a Welsh case, so I haven't given it any thought, to be honest. And then you have your 2 practice directions, which accompany the rules. PD 55A, the general rules, which expand upon the general points from the rules themselves. And then you have 55B, which is on possession claims online, or PCOL, as it's known. And then we have a little flowchart of the general progress of possession claims. You have the issue of service of the claim, you have the first hearing, and then you might go to trial. And then along the bottom there's the box of will the defendant respond? And that is crossing the span of issue/service and first hearing. I mean, in theory, it could happen at any point up to and including the trial if someone decides to engage much later down the process. But generally speaking, if someone's going to respond, they probably respond before the trial across those areas. So I'll address what to do if and when you receive a response from the defendant. So then going through the rules really, I guess, from top to bottom. So CPR Part 55 rules 1 and 2 tells you when you must use Part 55 rather than, say, Part 7 or Part 8. You must use Part 55 when a claim includes a claim for possession brought by landlords, mortgagees, licensors, or brought against trespassers, or in a claim for relief from forfeiture. And then I've underlined includes there because it might be that you're issuing a claim for a sort of a debt claim for unpaid rent. But if that claim includes also a claim for possession based upon forfeiture or a Section 8 notice, then you have to use Part 55. And you'll have to transfer from Part 7 to Part 55 to continue the possession claim. And then also in these rules, there's a definition of what a trespasser is. Now, this is it's a defined term for Part 55. It's a term of art. It's not used in the general sense of someone there without permission, because that could apply to a whole category of people. It has a particular meaning a claim for the recovery of land which the claimant alleges is occupied only by a person or persons who entered and remained on the land without the consent of a person entitled to possession of that land, but does not include a claim against the tenant or subtenant. Essentially, it's a claim against persons unknown, your squatters in the true sense, and licensees. And whether or not someone is a trespasser has quite strong procedural implications. It affects what form you use, how you serve the claim, how you serve the evidence, and also deadlines regarding the filing and services of any defence by those individuals. So it's really important that from the start you have this definition in your head and work out, am I alleging this against a tenant, or is this person a mere licensee? Or are they a classic broke in the middle of the night, held an illegal rave type squatter? Then in terms of starting the claim, there are some specific pre-action protocols which apply to possession claims, but not all claims. So if you are acting for a social landlord, there is a PAP for you to follow. Also, if you're acting for a lender seeking repossession of a property, if there's a mortgage or a home purchase plan arrears, then you should be following that pre-action protocol. But likewise, I'm not going to be addressing the mortgage claims in any detail here, so I suggest you go and watch the other landmark nuts and bolts online. Then in terms of which court to issue in, these rules are contained in Rule 3, of Part 55 and also expanded upon in the practice direction. It provides that the claim may be issued in any county court hearing centre. So in theory, you could have someone from your office pop down to a local county court, hand it over and get that court to issue it there, even if the relevant property is on the other side of the country. So you may do that, but I don't see why you would, because you'd have to have delays in transferring the claim that could incur more costs that you might not be able to recover if they argue, well, you should have done it in the home court of the property. So you may issue, but whether you should is a different question. And then should you issue it in the High Court? And the rules on that are in the rules on the screen, 3.2, 3.3, and 55A. Apparently, only exceptional circumstances justify starting in the High Court. That's from an objective point of view. It's not enough that your client really wants the property back. For instance, if there's a complicated disputes of fact, points of law of general importance, or if the claim is the claim against trespassers and there's a substantial risk of public disturbance or serious harm to persons or property which properly require immediate determination. So imagine the case where persons unknown have taken possession of a property which has a back garden, and the back garden is on the main train line into King's Cross. And the trespassers have been seen going over the wall and roaming around that train line. Now, that arguably might warrant High Court issuing because there's harm to persons, maybe even harm to the rail network as well. So that might be a circumstance in which you consider issuing in the High Court. And naturally, there's all the guidance about, 100K might be High Court, but nevertheless, it isn't uncommon for rent arrears claims to be in excess of 100K, but they can be extremely simple. It might just be that the tenant simply hasn't paid for a very, very long time. That isn't legally complicated necessarily, so simply the amount of money alone doesn't warrant issuing in the High Court. And the High Court then, if you do issue it there, can send it back down to the county court, which again adds more costs and more time. So it's really worth considering where to issue it. And also if you should just enforce in the High Court, assuming you get the order in the county court. And I think Kate or Miriam, I think it's Miriam, will talk to you a bit more about that later. Right then, starting the claim. Who should be the claimant and who should be the defendant? The claimant should be all persons with the right to possess the property. For instance, if there's 3 people or there's 2 people as the landlord under the tenancy, then they should all be the claimant in the action. It doesn't necessarily follow that the claimant in the claim is also the same person as the registered title holder if it's registered property. So it should be the person who's named the landlord under that agreement if there is a written agreement. Or if there's not a written agreement, who you say is the landlord even under that oral agreement. And the defendant should be the person who is in possession of the claim. If you don't know the name of the person, then you can issue the claim against persons unknown. And there's particular prescribed forms for the claim form and the particulars of claim. They're detailed in PDF 55A. I shan't go into them. They're all online on Google. You can type into them for free. But if your case is particularly complicated, or there's been, say, a series of land transactions, or you're trying to explain why they're licensees and not tenants, you could draft free form in Microsoft Word, but then I suggest you make it very clear that you are nevertheless including all the mandatory information as you are required to in the prescribed forms under the CPR. And as I said before, which form you use depends upon who your claim is brought against, at least in terms of the particulars of claim. Now, this is not a case where you can file and serve your claim form and then you've got months until you need to do the particulars. They should all be filed and served at the same time. And there's particular rules about what should go in the particulars of claim, unsurprisingly. And Part 16, where it doesn't conflict with Part 55, is incorporated into this, including the requirement to attach a lease if there's a written agreement. Then your particulars of claim. So the requirements to go in this are listed in 55A, paragraph 2. Unsurprisingly, it lists your requirements, quite obvious really, identify the land. But if it's quite complicated, for instance, it's just one part of a big title, it might be helpful for you to include in there a diagram identifying with a, say, a red border, the land which is in issue. You should state the basis for possession, whether or not it's residential property, and all the other details particularised in that rule. If you're relying upon rent arrears, then there should be a schedule of those rent arrears. And there's also more detailed rules if you're relying upon arrears from over 2 years ago. So I really recommend that you check and you follow that by the book. Even though you might think, oh, I've largely complied, what's the matter? It can be very easy for a duty solicitor or someone to find a particular point that's wrong in your pleadings and then try and delay the matter further. And there's furthermore particular requirements in rent arrears, trespasses and mortgage claims in the PD, so I suggest you go and have a look at those. Again, I shan't be going into them. Now, when is the hearing date? So the hearing date is somewhat defined by reference to however many days after the service of the claim. So the ordinary rule is that they must be served the claim form and the particulars not less than 24 days before the hearing date. I mean, in reality, the hearing date is whenever the court decides to give you a hearing. It might be quite quick. Normally, it is within, or at least after, the minimum time frame. It might be that you're waiting for quite a while, unfortunately. There are great backlogs, as we all know, and it's very, very frustrating, but you get the date that you're given. And also this rule contains requirements on service and when you should serve and how you should serve. If the claimant has served the claim form and the particulars, you should also have a certificate of service to certify that service at the hearing with you. You don't need to file it in advance. The rules expressly disapply that requirement, but there's no harm in doing so. Now, the court may reduce the time between the service and the hearing, but only in exceptional circumstances once again. So that isn't just, I will need the house back, I can't pay my mortgage. It's typically if someone has threatened to destroy the house or to come and attack the landlord because you want a determination quickly. In terms of then the defendant's response, so these rules are included in Rule 7 of Part 55. Now, the rules expressly state that there's no requirement to file an acknowledgement of service, and Part 10 on that doesn't apply. And then you cannot get default judgment against a defendant that doesn't respond. Now, it might be that their failure to respond in time or at all is to be, remedied or reflected in an order for costs, but you cannot get judgment in default of a defence being filed and served. Now, the rules state that in trespassers claim, they don't need to file and serve a defence. But I suppose in reality, if you are going to have trespassers turn up and actually fight the case on substantive grounds, for instance, by alleging that there's someone else with a better right to possession than you, then they would be wise to actually put that into a defence. Otherwise, the normal rules apply, file and serve within 14 days. But in reality, you can have a defendant rock up at the hearing and say, I need longer. And the court generally won't really inquire why. Again, that might be reflected in a costs order, but if they ask for time, they are usually given the time. And they're also allowed to participate in the claim, notwithstanding the first time you hear anything from them is on the day of the hearing. It's frustrating, but that's just really quite common. And just a practical tip, if you are acting for the claimant and you get served with a defence before the first hearing and it actually looks like there's something in it, there's, say, a strong claim for disrepair, or there is a estoppel or something which looks like it really might be arguable, the sort of thing that you think you might have to actually fight at trial. It might be worth, before the first hearing, just agreeing directions to trial or listing for a disposal hearing after you put in a reply, so that you don't have to get to the hearing, incur more costs for counsel, only then for the court to just simply order directions. And then I'd recommend doing that if you see that the defence is, per the 50R 5.8 test, which we'll come to next, disputed on grounds which appear to be substantial. Now, the first hearing. It's not a trial. It's very much not a trial. There's not meant to be any oral evidence. It is a very summary procedure. You might be listed for a 5-minute hearing or a 10-minute hearing, or if you're lucky, 15-minute hearing. You might be listed at 10 o'clock, along with another 30 cases. Mayors and City currently are listing every case for 5 minutes at 10 a.m. on a Thursday. You can be there from therefore 9:30 until maybe 4:30. So if you're going to Mason City soon, I suggest that you bring a packed lunch, advise your clients that if they're coming to be witnesses or to watch the case, they should prepare to be there potentially all day. It's extremely frustrating, but that is the current Mason City County Court listing practice. Now, when you actually get into the hearing, in that 5-10 minutes, naturally, the court cannot go through all the strengths in your case, all the strengths in the defendant's case and come to a conclusion. If, however, the defendant's defence is simply, and I've had it once, I morally object to Section 21, then the court shouldn't be pushing that off to trial. The court should decide then and there that that's not a good defence. All the documents have been served, and therefore I'm going to make an order for today. So if your case is really strong, there's probably no procedural flaws, then you might get an order on that day for possession. However, if there's any doubt, if the defendant comes along and even starts to perhaps allege disrepair without that much evidence in its favour, the court might just treat the hearing as a way of giving directions for what happens next, which could include giving more time for a defence or directing people to file evidence and then come back for a directions or disposal hearing when the court can consider, well, in light of this defence and the claimant's reply, is it worth still pushing this off to trial, or can we decide it then and there? Now, the court is supposed to give directions when it appears that the case is genuinely disputed on grounds which appear to be substantial. Now, that is the language from the CPR itself, but the key case on this is the Global 100 one on the slide. Essentially, this and the White Book says that the test is that for summary judgment, i.e., whether the defendant can show they've got a real prospect of success in defending the claim. So if the court listens to the defendant and thinks, okay, there's something in this, it's not just a moral objection, then they won't decide the case and will instead give directions. Now, in that first hearing, the evidence to be relied upon. So if it's a rent arrears claim, it's very important that you, on the day, have either the client there to confirm how much money is owing, or they filed and served a witness statement that very morning. As counsel, we can tell the court how much money is owing, but the court is very much welcome and open to say that they cannot take evidence simply upon our instructions. So if you want to minimise the risk of having any adjournments, you should have the client or a witness statement filed on that morning. It could be the witness statement only says, the arrears are as they were in my last statement. They haven't changed, or they have, but they've only gone up. So the court needs to have that evidence there. And that is particularly also addressed in 55A, paragraph 5.2. So you can bring up the evidence to date orally or in writing as necessary. And in trespassers claims, you should file and serve all the evidence you want to rely upon with the claim form and particulars of claim. You could do it late, but you have to, seek relief from the court and try and waive that procedural error. It's just not worth the risk. Then in other claims, you can file and serve witness statements at least 2 days before the hearing. And then you should maybe on the day of the hearing, if it's rent arrears, update the court on the position. You can also rely upon your pleadings if they're verified by statement of truth as evidence, but my preference would be you have a robust witness statement appending any documents that you need to prove your case. Now, if the defendant doesn't attend, it doesn't mean that you've won necessarily. You still have to prove your case, but it does mean that the court can still make an order. It doesn't have to pause and adjourn until they can attend. If the defendant has said, honestly, I've got the doctors or my child is very unwell and I can't leave them, then I think probably be wise to agree to adjourn it, provided there's evidence for that, of course. But if there's no reason given or the reason is given without any evidence, then the court can and probably will proceed in the absence of the defendant. But in that case, then, because it's not a trial, nevertheless, Rule 39.35 applies by analogy, and there's the case law relevant there is on the slide. So if the party doesn't attend the trial and the court makes an order against him, then the defendant may apply to set aside the judgment or the order if these 3 circumstances are satisfied. That is, they acted promptly when they found out about the order, had a good reason for not attending the trial, and had a reasonable prospect of success at the trial. So, for instance, It's not enough that the defendant says, I made this application a day after I found out, and I didn't attend because I was in A&E, but nevertheless, I've got no defence. I admit the claim. So they might have met A and B, but they won't have met C. So Rule 55, while Part 55, it is largely quite a self-contained code. Other parts of the CPR do apply. There's more on this in the White Book as well. And in terms of costs, you can't get costs against persons unknown. So perhaps if someone does turn up from persons unknown, get them to give you their name, and then you could try and seek costs against them. But you might decide it isn't really worth it, chasing them and enforcing them, etc. Now, check before you go in if fixed costs apply. So that, for instance, it might be if it's a rent arrears claim and no one has turned up or put in any defence contesting the amount that they're owing, you might be restricted then to fixed costs only. However, if there's a costs clause, so a clause in the AST whereby the tenant covenants to pay costs, maybe indemnity costs or reasonable costs or whatever, in the event of breach, then you can rely upon this, notwithstanding fixed costs would apply per the rules. And therefore, it might be worth filing and serving an N260 if you think the defendant's going to turn up. Of course, it's worth filing and serving in any event if you have got a cost clause or if they have filed and served a defence. If your case does get past the first hearing, there is a substantive basis for defending it, and the court decides to put this to trial, then there'll be the matter of track allocation in the normal way, and the rules on that are in Rule 9 of Part 55. There'll be your usual directions, for instance, disclosure, evidence of fact, maybe expert evidence if there's, say, a disrepair counterclaim, etc. So in that way, then the claim becomes more normal, as it were, with other perhaps Part 7 disputes of fact trials. And then Part 55 has a bit less of a role to play. I think that concludes my part, and now passing over to Kate to talk about receivers.
Thanks, Sophie. So yes, I'm going to speak to you this afternoon about possession claims by receivers. And what that sort of is going to entail is almost bringing it back to basics in light of questions or issues that have arisen on cases that I've had over the last few months, or which I know colleagues have had. So it seems fitting to put all those answers into one nice area where you can find them, and therefore it's in my presentation. So what this is going to include is addressing sort of 6 broad areas. The first is whether or not LPA receivers can seek an order for possession. Then we're going to have a look at the effect of various provisions under the Law of Property Act. Then we're going to see whether or not receivers can serve a notice. Then we're going to look at how to issue proceedings. That's not going to cover what Sophie's just taking you through, so don't worry about that. But what we're going to be looking on is whether or not to issue in the borrower's name or the receiver's name as agent. And then we'll briefly recap Menon and Pask, and then finally we're going to look at Section 36 of the Administration of Justice Act and whether in principle it can apply to receiver claims. Next. So the short answer to whether or not a LPA receiver can seek an order of possession is yes, but we're going to take you through the basics as to how we get to that answer. And where we start is that the right to appoint an LPA receiver under the Law of Property Act arises when mortgage money has become due, and that's set out in Section 101. That right is only exercisable when one of 3 conditions for the exercise of power of sale is satisfied, which is set out in sections 109 and 103. However, it is common for that statutory power to be varied under the mortgage deed so as to be exercisable immediately on default. So it's also worth checking what the mortgage deed says whenever you get an LPA receiver claim in. Next. We can just go back one. So section 1093 of the Law of Property Act. I'm not going to bore you all by reading what's in front of you. I'm sure you can read through that at your leisure. But what this is the power can be explained as having the effect of the receiver's power to collect income under section 1093. It's not an assignment of the right to income by the borrower to the receivers, rather it's a substitution for the borrower. In other words, the borrower can no longer collect the rent. So when you notify an occupier of the receiver's power to collect rent, then it becomes due to the receiver. If the occupier refuses to pay the rent to the receiver, then the receiver can sue the occupier successfully for recovery of any debt. So essentially, under this provision, the a receiver has the power to demand and collect rent and other income, and they act as an agent of the mortgagor, and in doing so they can exercise any powers which have been delegated to him by the mortgagee under the deed. Moving on to section 101(3). So what does section 101 paragraph 3 mean then? Well, this enables a mortgagee to confer express powers on a receiver in addition to the statutory powers. Commonly, the mortgage deed will confer wide-ranging additional powers, which may include the power to obtain possession of the premises. But just circling back, it usually includes that variation I mentioned earlier, which is that it can be exercised immediately on default. Next. So the right to serve a notice by an LPA receiver. Well, this is the situation which actually arose in the case I've cited for you, McDonald and McDonald, which was appealed to the Supreme Court on other issues, but in the focus of the case before the Court of Appeal, it was considering the mortgage conditions and whether or not they gave the LPA receiver a power to obtain possession. In this case, it was argued that the receivers had no power to serve a notice under section 21, that being required by the landlord. And Lord Justice Arden dealt with that point quite shortly, and what was said was that the mortgage conditions have to be interpreted purposefully. The clear purpose of the mortgage conditions was to enable the receivers to proceed to realise the charged property in an orderly and efficient way. The powers conferred on the receivers must therefore include a power to do anything which is necessarily incidental to the exercise of the specified powers. In short, what that means is that a mortgage must be interpreted purposely, and serving a notice under section 21 is incidental to that power to obtain possession. Now, Lord Justice Arden addressed the point in section 45(1) of the 1988 Act, but that defines landlord as follows: any person from time to time deriving title under the original landlord, and also includes, in relation to a dwelling house, any person other than a tenant who is, or but for the existence of, an assured tenancy would be entitled to possession of the dwelling house. So one analysis would be that since receivers are entitled to possession, they would fall within the scope of section 45. Another analysis is that receivers, as agents of the borrower landlord, are entitled to sign and give notice as an agent signing on behalf of a principal and with their authority. And that's also been discussed by the editors in the Mortgage and Receivership, which is a leading practitioner textbook on this. And what they say is, in relation to deemed agency, is that in most cases, this will provide the answer. In general, there is no reason why receivers cannot serve any necessary notices in the borrower's name simply by reason of the deemed agency, and if they have the power to take possession as deemed agent of the borrower. So short point is they can serve notices to issue possession proceedings. So proceedings issued by an LPA receiver in respect of property against third parties, they are usually brought by the receiver as an agent for the borrower. So what that means is they're usually issued in the name of the borrower acting through the receiver. The effect of this would be to make the borrower primarily liable for any cost order. That's something to bear in mind when you are issuing proceedings, particularly if you have a borrower who's on the edge of bankruptcy or some form of corporate insolvency. However, if we assume that a mortgage expressly gives the LPA receiver power to obtain possession of the mortgage property, where a receiver is exercising their power in respect of that mortgage property against the mortgagor, then proceedings should be brought by the receiver in their own name, including in respect of a claim for possession of the property against the mortgagor. And there's two important points to note from that. So generally, the receiver will rely on the power to take possession, which they have because of the mortgage conditions set out in the deed. And the other point, which will come on to the decision where this arises from, is that a mortgagor cannot sue themselves for possession. Instead, the receivers sue for possession in their own names. And that was discussed in Menon and Pass, which I'll come on to. So, Menon and Pass, what is this case? This is a case that concerned defendant mortgagors who were granted a loan made to a company by the Bank of Singapore. The Bank of Singapore had a mortgage over their home property. Bank of Singapore then demanded rent and appointed fixed charge receivers over the property to recover possession so it could be sold. What then happens is the receivers issued possession proceedings, and they issued them erroneously in the name of the company. They then amended them so they were brought in the name of the mortgagor acting by the receiver, as that's the usual form, as I've mentioned, when receivers seek possession claims against third parties. At first instance, the mortgagors argued 2 points. The first was that it's not possible for receivers to bring possession proceedings in the name of the mortgagors, with the receivers acting as deemed agent. And the second was that Section 36 of the Administration of Justice Act applied to proceedings where a receiver claims possession of a property occupied by the mortgagor. And in that case, the court should exercise its discretion in favour of the mortgagors. Both arguments were dismissed and an order for possession was made. There was then an appeal brought. In the course of the appeal, the pleadings were amended so that they were brought by the receivers in their own name. And then it was argued that there was a freestanding right to possession. What the courts decided was that receivers can sue a mortgagor in occupation for possession in their own name, and that their right to possession is derived from the special nature of an agency relationship between a receiver and mortgagor. And what was part of the analysis is 4 reasons given in paragraph 26, which is on the slide before you. And just breaking them down, they are, in this case and in all cases, receivership would be known to be carried out in the interests of the bank, not the mortgagor. The property would be known to be a dwelling house in occupation of the mortgagors, therefore the most likely person against whom possession would be needed. The receivers had a power of sale, and the parties would have expected such a sale to be with vacant possession, so the receivers would need possession against most likely possessor. And other powers given to receivers only make business sense if they have possession of the property. So the short point out of that is that when you are bringing a claim against the mortgagor who is in occupation, the way in which the proceedings ought to be brought is via the receiver's name. It shouldn't be in the mortgagor's name, because Lord Justice Mann held that they can't sue themselves, and that would be how the claim would be structured. So, Section 36, and the reason I bring this up is because this is probably one of the most significant aspects of the Mann decision. It was previously assumed that Section 36 didn't apply to receivers seeking possession against mortgagors in possession of a property claim, but the judgment of Menon actually gave borrowers in occupation of mortgage property the same right to ask the court to exercise its discretion as they would have if the lender had brought possession proceedings. So what Section 36 does is it gives the court a broad discretion in mortgage possession proceedings to adjourn those proceedings, or to stay or suspend the execution of the order for possession, or postpone the date for possession. And previously it was thought that that couldn't apply in context of receiver claims, but Mannon changes that. So if we move to the next slide. In answering the question, does section 36 apply? It does apply in principle, and that the answer to that is in Menon and Pask. What the court said is that section 36 applies to receivers when suing for possession for several reasons. The court decided that receivers fell within the definition of a mortgagee in the Administration of Justice Act, section 39, because receivers derived their title from the mortgagee, and that such conclusion would coincide with Parliamentary's intention in enacting section 36, that although receivers act as agents for the defendants in that case, the reality is they're appointed by the bank as mortgagee to enforce its security, and that section 36 usually applies where a mortgagee is enforcing a mortgage via proceedings, so as to give a borrower an opportunity to pay or remedy any defaults. When you have receivers suing for possession, they are essentially making the same claim for the benefit of the mortgagee. So as a matter of principle, individual property owners should have the same opportunities resisting possession under section 36 as they would have if the mortgagee had been the applicant bringing those proceedings. It is important to note that this judgment only concerned whether or not it applies as a matter of jurisdiction when suing for possession against a mortgage or an occupation. There would still be discretion for the courts to consider the application of section 36 in the context of any claims and how best to proceed with any requests under section 36 by the borrower. So that concludes my part of the discussion. Thank you very much for listening. I'm going to pass over to Miriam, who's now going to talk you through the enforcement issues that arise in possession claims.
Right, enforcement of possession orders means you've got your possession order from the court, you've done a lot of the hard work. Hopefully you'll have an order which gives you what's called an outright possession order, saying this person, the defendant, needs to give you possession on this date. The question then is, how do you enforce that? And what I've got for you is, I wouldn't call them fun facts, but 10 points worth knowing about the enforcement of possession orders, and I've ranked them in order of importance, in case the attention span is waning. So you've got your possession order, the occupant is not leaving voluntarily, so you move to the enforcement process. What do you need to know about this process? Okay, firstly, number one, and this is often overlooked, the importance of your actual possession order being made on a mandatory ground. So when you seek, or on section 21, so when you seek possession against an assured shorthold tenant or an assured tenant, there's what's known as mandatory grounds and discretionary grounds. Mandatory grounds are in part 1 of schedule 2 and discretionary grounds is part 2. And it's exactly as it's labelled. If it's mandatory, you've just got to prove your ground. So this amount of rent has been outstanding. The court has no discretion. They must make the possession order. Part 2 is the discretionary grounds. And not only do you have to prove the ground, but then the court has to be satisfied that it's reasonable to make the possession order. There's a lot more scope for the judge to feel sorry for the tenant, effectively. There's a lot more discretion on the judge's part. If you get your possession order on a mandatory ground, the whole enforcement process is a lot more in the landlord's favour. And that includes, so that's a mandatory ground under section 8 or an order under section 21. If all you can get, for whatever reason, your section 8 notice was bad, or you just can't quite make out any of the mandatory grounds, so you can only get possession on a discretionary ground, the effect of that when you come to execution of a warrant is that a court has a lot more, again, more discretion. So they've already had discretion whether to make the possession order, but they have a lot of discretion as to whether to postpone the date of possession, which includes suspending a warrant of possession. So the relevant statutory provisions are those up on the screen. But basically, if it's made on a mandatory ground, the court has unlimited discretion to suspend. So there's no sort of time limits on how far they can push back the date of possession when it comes to execution. But if it's made on a mandatory ground, it's extremely limited. The court can't push back the date any longer than 14 days from the date of the order, and a maximum of 6 weeks in cases of exceptional hardship. In practice, when you get to the warrant stage, you're already well past these deadlines. So the short point is, if you want to, if you can get it on the mandatory ground, try to do that, because the landlord's position is quite strengthened if you can do that, even at the warrant stage. It's essential that your possession order actually records what ground it was made on. Now, this used to be more of a problem because the judge was just sort of freestyling the drafting of the order, and unless you ask for it, the judge would not put in there what ground possession was ordered on. Now, it seems to me that the judges are using this sort of tick box form. So there's a box where they have to tick whether it was mandatory or discretionary, and that box sort of formulates the order for them. So you don't see that kind of omitted. But I would, if you're doing your own hearings, or if you're instructing counsel, it is worth checking with the judge. By the way, if you are satisfied that I've made out a mandatory ground, can we make sure that that's on the face of the order? If it's not on the face of the order, then you will struggle in showing that it's a mandatory ground. Okay, so that's the first one, and I put it top because it's sort of a bit unknown, but it really changes the landlord's position. Okay, number 2, this comes up all the time. Application to transfer. So this is where, your possession proceedings will have been in the county court, and you've got your possession order, but everybody's told you that the bailiffs, there's a big backlog in enforcement in the county court. So I've heard something like 6 months in some courts for the bailiffs to actually get a date when the bailiffs are going to go in. And that could sort of double the length of the proceedings from start to end. You might have got your possession order in 6 months, but now the bailiffs are telling you it's going to be another 6 months. So the obvious solution here is to transfer your claim, or the enforcement of your claim, your order, to the High Court. And everybody wants to do this. Everybody always asks for this. The court has the power to do this, and I think it's clear that it will be quicker in the High Court. But I'm finding that it's not sufficient to just ask for it at the end of it. So you have your possession order, and then you just say to the court, oh, also, can we transfer it? It's so slow. The bailiffs are so slow. There's such a backlog. So I would emphasise, firstly, the importance of actually making a formal application. At the very least, state it on the claim form or the particulars of claim somewhere, that not only are you asking for a possession order, you're also asking for transfer. If a step up from that is to actually put in with the claim an application form on an N244. Secondly, the importance of evidence to support the application. It's not really sufficient to just say, oh, everybody knows there's backlogs, bailiffs take ages, I need to get to the High Court quickly. I would say the evidence needs to address 3 things. Firstly, the hardship to the landlord caused by further delay. And you've got to really go a step further than just, this is ridiculous, they've been in possession for so long, I want the property. As sort of unique to the circumstances as possible is best. Secondly, any evidence you can get on the delays in that actual court. So either anecdotal evidence from a solicitor, the instructing solicitor, to say, I operate in Wandsworth County Court a lot. I issue a lot of claims here. As I understand, on the last 2 claims I issued, this was the delay with the bailiffs. Or even better, I called the county court, the office yesterday. I've tried to get information about what the kind of lead-in time would be, and they have told me as of yesterday we would not get a date within the next 6 months. So some sort of actual evidence, as best you can, to really prove to the judge that there is a big backlog. It doesn't seem to me that the judge will just sort of take that as assumed that there's a backlog. And thirdly, this evidence should try to address that transfer would not cause any prejudice to the tenant. So apart from the fact that it will obviously be quicker, it's worth emphasising that there are protections for the tenant, even if it's transferred to the High Court. So to try to address those three things. And I would just finally say, this is quite an unpredictable game, asking for applications to transfer. There's no harm in asking, apart from the costs of drafting the application and the evidence. But it is worth warning clients that courts can be quite inconsistent in it. Courts can be inconsistent, and judges within those courts can be inconsistent. Certain courts are developing reputations for sort of refusing to transfer, and some other being very ready to do so. So it can be quite unpredictable. Right, the third point is that, well, let's just start with the normal process of how you get a warrant of possession. So you've got your possession order, and usually all you have to do is you apply to the court for an appointment date. So that's just a standard form. It's sort of an administrative process. It's not an application really to the court in the normal way. There won't be a hearing or anything. It's an administrative process. You fill out this form once the possession date has passed. That's the usual process. But there are certain cases where you're going to need, there's a sort of extra layer of protection for the tenant or the occupant, where you will need the court's permission. And the situations where you need permission are set out in the rule on the screen. The main situations where you would need actual court permission for issue of the warrant is the following: either when the possession order is a suspended possession order on grounds other than the payment of money, so not a suspended possession order on condition of payment of rent arrears. You don't need permission for that, but something like suspended on the condition of complying with certain terms of the tenancy agreement, so sort of behavioural things. Or if there's a change of the parties, so perhaps the property's been sold in the meantime, so the person entitled to possession is no longer the same party. Similarly with the tenant, if the tenant has died, that would be a change of the parties. It's also you also need permission if your possession order is sort of expired, if it's gone over 6 years. A possession order is not invalid if it's 6 years old or over 6 years old. It's just that you have to go through this extra hoop of getting permission. And then there's a significantly shorter deadline when it comes to possession orders against trespassers. If your possession order against trespassers is over 3 months old, then you're going to need to get specific permission from the court. As I said, this is just another hoop to jump through. It's still not really a proper application process, in that it's applied for without notice. You just use a different form to the other form that you would otherwise use. But that is another hoop to jump through. And if this permission is not obtained properly, then it puts the warrant at risk of being set aside. This is in the county court, by the way. It's a bit different in the High Court, but I'm not going to go into the kind of subtle differences between the two. But this is assuming you're applying for a warrant in the county court. Right, number 4, breathing space moratorium or a mental health moratorium. You can't proceed with the enforcement process if the tenant is in a breathing space. So that's just an absolute prohibition. Number 5, trespassers are subject to special rules, and this comes up time and time again in Part 55 itself, as you've seen, but it comes up again in the enforcement process. The first point is that you don't need actual permission to transfer to the High Court if you've got an order against trespassers. So this is forgotten quite a lot, but that's a very useful statutory instrument to remember, which is that you don't actually need the court's permission, so you don't actually need to request it. The most popular way of doing things seems to be by using this N293A. And so this is only against trespassers. What you do is you have your High Court enforcement officer with your barrister at the county court. You get your possession order against trespassers. You ask the court staff to type it up and seal it as soon as possible. You then linger outside the court office for that order, hopefully not too long. And then then the High Court enforcement officer takes that order and the N293A, which needs to be stamped by the court office. And those two in itself is sufficient to get to apply for a writ of possession in the High Court. So with trespassers, first point is that you don't need to really be asking for permission to transfer. You shouldn't be going through that whole rigmarole of, I need it to be quick. There's no prejudice to the occupier, etc. It's a lot more of an automatic process, and best way is to use the N293A. And the other way in which claim against trespassers differ is that you don't need to give notice of eviction. Now, I'm going to come on to the requirement of notice. The introduction of a requirement of notice is actually quite a new thing, certainly in the county court. And with trespassers, there is no such requirement. So this whole process of applying for the warrant is done basically without the input of the trespassers at all. No need to give them any notice of what's happening. But I would just give you a warning, which is you need to be very clear about what a trespasser is. Sophie touched on this. A trespasser is not just someone who is there without any legal right to be there. A trespasser is someone who entered the land without legal right to do so. A trespasser is not a tenant who overstays. Okay, number 6, notice of eviction. And this is the new bit. This was a COVID innovation, which has now been made permanent. So if you haven't done enforcement of possession orders for a while, this is new. And this rule is, all this stuff is found in one rule, which is 83.8 big A. Effectively, it's to give the tenant 14 days notice that the bailiffs are coming. But it's quite easy to get this wrong because the rules, firstly, they require the form to be addressed not just to the defendant, so the people who are named in the possession order, but also it has to be addressed to the occupiers, so to all occupiers. It has to be in a particular form, which is the N54 form, and it has to be delivered to the premises 14 days before execution. If something goes wrong and you give the notice 14 days before, but for whatever reason the bailiffs don't manage to attend on that day, you've then got to give another 7 days notice of the next eviction date. I'd emphasise there's special service rules here which differ from the normal service rules in a normal claim against tenants. The notice of eviction and any further notice of eviction have to be delivered by, and this is similar to the sort of the service on trespassers nature of service. So it's got to be either inserting it through the letterbox in a sealed, transparent envelope. That's quite unusual because you wouldn't normally send letters in sealed envelopes, in clear envelopes. Or if it's not practicable, then attaching it to the main door or some other part of the land so it's clearly visible. Or if that's not practicable, placing stakes in the land in places where they're clearly visible and attaching to each stake a copy of the notice in a sealed, transparent envelope. So there's special service rules about this notice. The court can dispense with this requirement, so they can extend or shorten the notice period. If that's something you want, you would be well advised to ask for that within your possession claim. So you get your possession order, and at that stage you ask for the court to dispense with or shorten the period. Obviously, you have to have a reason why this 14-day notice period is sort of too much in your case, and why it would be so prejudicial to the landlord to have another 14 days given to the tenant. So that's the new bit, notice of eviction, and that does give the tenant quite a significant greater protections than they normally have. Number 7, expiry of a warrant. A warrant does not live forever. It has a 12-month lifespan, but it is capable of extension, and you would be well advised to apply for any extensions within those 12 months rather than afterwards. Right, applying to suspend a warrant after eviction. So as I said before, there is scope the court has powers to suspend a warrant, and quite significant powers, before the eviction actually takes place. Now, after eviction, this is significantly limited, and the court really only has this power in 2 cases. Either if the possession order itself is set aside, that has a knock-on effect. If the possession order was not valid and it's set aside, then the warrant that's based on the possession order was also not valid. or in cases of fraud, abuse of process, or oppression in the execution of the warrant. So quite limited circumstances after eviction. Number 9. The bailiffs can evict anyone on the premises, and this comes from a case of the case on the screen, the Wandsworth County Court case. This is sort of bandied about quite a lot, and I think if you really take it to its absolute limits, this principle, then you sort of never have to issue against the right person or claim against the right person. It is obviously important to get the correct defendant, but there is a habit of sort of including as additional defendants people you might otherwise might be on the property. So you issue against the tenant, but you also issue against the children of the tenant who you know are living there, or the wife of the tenant who you also know is living there. Or sometimes there's a habit of issuing against the tenant and then saying, I think there's other people living in the property, so I'm just going to bung in persons unknown as the second defendant. Usually this is unnecessary. To add persons unknown as a second defendant is usually unnecessary. I don't want to discourage people from doing it in all cases. I think it's something worth taking advice on, because the point is that the possession order operates in rem, which means it's against the property. It's not really against the person. And so on the date that the bailiffs get there, they are entitled under the warrant to evict anyone that's there. And it is worth bearing that in mind at the beginning of the process, when thinking about who actually needs to be added. And finally, number 10, this is about re-entry following eviction. So you've gone through the process, the tenant has been removed by bailiffs, or the trespasser has been removed, but then a week later there's someone else on the premises. What can you do? Do you have to start all over again? The first point I would say is try to avoid this by securing the premises properly, and having that ready very soon after the bailiffs go in. The only way of preempting this is just to have all the security set up so this doesn't happen over and over again. If it does happen, you've got two options: either starting proceedings again or applying for a warrant, what's known as a warrant or a writ of restitution. And this is sort of an attempt to, without having to issue fresh proceedings, you sort of reinforce the order that you already had. You need court permission to do that, and you will only get permission if you can show a connection or an overlap between the old trespassers or the old tenant and the new trespassers or the new tenant. So you need to show that it's either the same people or very much related people, and that has to be supported by evidence. There is limited case law on when, how is that overlap or how is that connection supposed to be tested. Your other option is to just issue fresh proceedings. My own view, and I consistently advise that it can often be quicker to just start fresh proceedings, because you are going to have to go. There is a likelihood you will have to go before the court and sort of argue on the facts that there is an overlap or connection between the old and new trespassers. And that might be disputed by the people currently in occupation. In that time, you may very well have just been able to issue what could be a very straightforward new claim, which is these people entered the premises with no permission, and therefore they're trespassers and we want an order forthwith. So this option does exist, a writ of restitution. If you are confident it's the same people or very similar people, then go for that option. If not, consider issuing afresh. So those are my 10 points worth knowing about enforcement process. I think now if we turn to some of the questions, if we start with some of the questions that Sophie was going to answer, feel free to send in more questions. We have received a lot. I'm going to start with this one for Sophie. In practice, what happens on costs when there's a substantive dispute of fact? The defendant tenant has good conduct, but the court ultimately sides with the landlord. Does the default rule apply to costs, and is the defendant liable for the claimant's costs?
So then, assuming that we are in the territory of a first hearing, if I understand it right, there's a first hearing, the landlord's won. The the defendant might have put up an arguable case, they might have made some allegations, and there was a dispute, but ultimately the court's come down on the side of the landlord. In that case, then the usual rule applies, costs follow the event, and the landlord is the successful party, and so, at least in my experience, should get its costs. I mean, that the defendant's conduct might impact the basis for the assessment. So it might be that it's standard basis rather than indemnity basis, because they were simply raising a point that they just weren't believed upon. They weren't lying, they just didn't, bring up to the balance of probabilities. So, and I guess it could be the standard basis insofar as that's not inconsistent with a cost clause, which states, the indemnity basis should be paid. But yeah, in my experience, at least, the default rule does apply, even if some good points are raised by the defendant.
Yeah, and also, Sophie, just to add to that, there might be fixed costs rules which apply. So although the landlord might be entitled to their costs, there might be some limits on what those costs are. And if it would be fixed costs, it would be very limited. The best way to get around the fixed costs rules is to point to a provision in your tenancy which allows the landlord to recover costs of, hopefully the clause will be as broad as possible, and that they can recover the costs of any enforcement proceedings or anything arising from the tenant's breaches, and then you can rely on that to say that this trumps the fixed costs rules, and that will help you get as much cost as possible. You will almost certainly have spent more money preparing the claim than the judge is willing to award you. Right, next question. Yes, Sophie, there was one about, do you have authority for filing a claim in the name of the landlord named in the tenancy rather than the registered proprietor?
So there are authorities, but this is more part of the general principle that the claimant should be the landlord, and second, that a tenant is stopped from denying their landlord's title to the land, so that the defendant can't say, well, you're not the proprietor, so therefore you can't get possession against me. I mean, it's addressed in more detail in Woodfall on Landlord and Tenant at paragraph, I think it's 1.037. It cites lots of cases how there are tenancies by estoppel. And so this creates an interest as between the landlord and the tenant rather than a proprietary interest in that land. And I suppose the most famous estoppel case would be the Bruton one, Bruton and London and Quadrant Housing Trust in the House of Lords. I mean, I had a case in, I think it was Wandsworth County Court, when the claimant was the registered proprietor, but the landlord was a different person. And I tried a clever agency argument that the landlord under the agreement was acting as agent for the claimant, and so actually they were one and the same person, so it didn't really matter. I mean, that didn't slide, didn't work, unfortunately. But it might be wise to join the registered proprietor to the claim as claimant, because I think the rules do say that everyone entitled to that remedy that you seek should be joined as a claimant to that claim. But there's no particular authority per se, but if you want to go and read the case law from Woodfall, it's generally quite old. Yeah, paragraph 1.037 is where to go.
Thanks, Sophie. And one for Kate. If the tenant leaves the property while possession proceedings are underway and doesn't dispute the proceedings, would you request a default order for possession or try to get an agreement in writing with the tenant to confirm that they have left and that they won't pursue possible legal costs if the proceedings are discontinued?
So I think the context needs to be given to this. If you're at or before your first hearing, then there would be nothing preventing you from going to your first hearing and explaining the position to the judge and potentially having, some form of evidence with you that the tenant doesn't, object or dispute the proceedings. I think if you're later down the line in proceedings and, they've originally gone to the first hearing and said, I've got a defence, and they then later decide they don't dispute it, then you'd want to get, a consent or a TOM order drafted up between the parties and signed and put before the court disposing of the proceedings with no order as to costs. I think that would be the appropriate sort of way to deal with it. But I don't think you can just, I think you'd either have to get an order for possession or you'd have to get a consent order or a TOM order by agreement. I wouldn't just leave it hanging in the balance.
Thanks, Kate. But lots of people asking about the N54, and this did come up when I was looking at this. There's a real question as to who has to serve the N54. Now, I've heard that the court send it, and the court might, by that might mean the bailiffs. So I think I mean, if somebody has experience of this, then please put in the Q&A your experience of this. My understanding is that the court does it, but I think that means that the bailiffs do it. My only concern there is just that obviously they've got to get, the responsibility really is, it all falls back to the landlord. So if the bailiff's not doing any of that process properly, or if the court's not doing any of that process properly, then the landlord's in trouble. In particular, the service provisions. And so you're relying on the bailiff to put it in a clear plastic envelope and put it through the letterbox or put it on the main door. If that is the process, then that's the process. The landlord doesn't need to bother with that. But the truth is that I don't have experience of that actual process. I think there is some sort of ambiguity there, but it has to be on that form, and it has to be served in that particular way.
I don't know if touching, but I've had this recently in a case where my understanding is it's the bailiffs that are supposed to serve this, or the enforcement agent that's supposed to serve this, and when it goes wrong, you can either sort of, we applied to abridge the time for service. The judge said no, they wasn't going to do that because they're entitled to the full 14 days notice, but my judge was very helpful in that case and went down to the bailiff's office and got it listed a lot sooner than sort of the 6 months it would have taken if it just gone back to the backlog. But my understanding is it is the bailiffs that are supposed to serve that form, and there's not much you can kind of, or they don't really tell you when they're serving it or not serving it, and they can make mistakes with it, which then means you kind of have to deal with the consequences of them not getting it right.
Yeah. I should also clarify something about the breathing space moratorium and the mental health space moratorium. That is only enforcement of possession orders based on rent arrears or other money payments. So a Section 21 or enforcement of a Section 21 possession order would not fall within those restrictions. Right, some questions about when you're putting a witness statement together, asking the court to transfer to the High Court. What did I mean by the third element of that, which is addressing any prejudice to the tenant? This might not always apply, but it in the sense that it might just be the normal argument, which is that the tenant's had long enough, these proceedings have gone on for ages, why give them more time just from the delay of the bailiffs? But there might be something specific to the case. For example, that the tenant's not actually living there, or it's only their second home, or something specific to the case, which allows you to say that this extra speed afforded by the High Court enforcement officers is not going to be prejudicial to the tenant. It might not always apply, and it also might just be a matter for submissions, which is that tenants do have various protections in all cases. And those would not be different in the High Court. So it might not be evidence, but worth considering, I think. Someone's mentioned the shelter. Someone said, well, you said this, but the shelter website said this. I love that, because the shelter website is an amazing resource and is 9 times out of 10, go with that over what I'm saying in this webinar. It's an excellent resource, the shelter website. So I'm glad that people are looking at that. One question that we've had is, if you're claiming in the alternative, and so you're saying either this person is a licensee whose license has been terminated, or they are if it's a tenancy, which we don't think it's a tenancy, but if it is a tenancy, then we're terminating on this basis. If you're claiming on those alternative grounds, is your claim a claim against trespassers in the true sense? Because one of your cases is that it's a licensee who's overstayed. Your other case is that it's a tenant. Sophie, I don't know whether you have any thoughts on that.
I think the question was particularly in terms of like how you draft it. I'd probably draft it then free form in Microsoft Word and say, well, it's based on the alternative bases, the prescribed forms are this, this particulars of claim adopts the content from that, and then you would just draft like you would any other particulars of claim,
Yeah.
referencing in all the elements from PD 16 and the PD 55A, and then state your alternative bases. But then in terms of whether the service provisions would apply and whether because they're fundamentally really quite different. It's not a persons unknown case. So
Yeah.
those particular rules wouldn't be applying then, because necessarily you can't say, I know who they are, they're my tenant, but they're also not. They're also persons unknown. So then you've not got to worry about all the transparent envelopes and stake to the land.
Yeah, I mean, the truth is that the actual procedure going forward with the claim is not that different, whether it's a trespasser or not. I don't think that there's a different claim form. It's the same N5 claim form. Is it a different particulars of claim? It's a different particulars of claim. Yeah, I would agree. I would just do it free form, as you suggest, which is often appropriate when the claim is sort of slightly more complex. And then when it comes to service, you don't need to, it's not persons unknown, so you don't need to comply with a special service provision. And that's it, really. There's not that many differences in the two procedures apart from that. I think we're coming to the end of our questions. Unless Kate and Sophie, there's any others that you want to take. Oh, someone's asked, are there different procedures for extending a possession warrant before its expiry or after the said expiry? I don't think there's a different process. It's just that your prospects of an extension are greater the sooner you do it. And throughout the CPR, there's quite a distinction between when you apply for an extension of time before expiry of the deadline and when you apply for a sort of a retrospective extension of time. So I would always advise to do it sooner rather than later. I mean, I am curious as to how you get a warrant and let it expire after 12 months. But if you are in that situation, I would definitely advise get an extension as soon as possible. I want one more question, more relevant to commercial property. In your view, does a possession claim against trespassers cover a situation where the landlord has peaceably recovered possession following expiry of a contracted out tenancy and the tenant subsequently breaks back in? I mean, I think that's sort of a borderline, because the first time they went in, they did have permission to be there, so they were not trespassers. But the second time they went back in, they didn't have permission. So I can see the difficulty there. I mean, again, it just doesn't really, there's not that much difference between the way that you proceed with these two claims. So I think in that situation, you can always just do the particulars of the claim in a sort of free form way. As long as it's not against persons unknown, you don't need to do special service, comply with special service requirements. So I would not sort of treat it as a trespasser's claim in that case. Right, I think that comes to the end of the questions. So thank you so much to everyone for joining us. As I said before, the presentation and the video will be sent out afterwards. It's also available on YouTube afterwards. You should get a link to that. Otherwise, you can find it online. So thank you very much for joining us and have a lovely evening.